So my presentation today focuses on an issue that I'm very passionate about and that I've been working on for many years. And that is looking at the rights of persons with disabilities, and in particular, looking at how to ensure accessible justice for clients with disabilities. So we will be looking at some of the barriers that clients with disabilities often face in the criminal justice system and in the justice system in general. And what I'd like to do is first talk a little bit about the legal basis for understanding disability and disability accommodations under international standards on disability. Look at some of the common barriers that people with disabilities experience in the justice system. Look at some of the key concepts that are very important to know in order to identify and then dismantle barriers that persons with disabilities face. We will look at a few examples from different countries on what's being done to help advance more accessible justice. And then I'll be going through some of the basic guidelines that have been developed to assist lawyers who are representing clients with disabilities. And then I have some additional resources in case you want to explore this topic further. So what are some of the international standards relevant to ensuring accessible justice for persons with disabilities? The first that's very important to know about is the Convention on the Rights of Persons with Disabilities. This is an international treaty adopted by the United Nations in 2006. It was a treaty where China led very much from the very beginning of the process. China was very deeply involved in the drafting of the treaty. And of course, China ratified the treaty very early and has been working on implementing it ever since then. The Committee on the Rights of Persons with Disabilities is the body that monitors the treaty. We have had Chinese representatives as members of the committee. China has appeared before the committee. And then finally, we have guidelines adopted by the UN Special Rapporteur on the rights of persons with disabilities. So these are really the three really important guidance tools that we use to think about how to improve accessing justice for clients with disabilities, both the treaty as well as the guidance coming out of the Committee on the Rights of Persons with Disabilities and guidelines that have been adopted quite recently by the UN Special Rapporteur. So what are some of the key concepts that we need to keep in mind when looking at disability from a human rights-based perspective, or from the perspective of the Convention on the Rights of Persons with Disabilities? Well, the first is to understand the social model understanding of disability. And this is the model that understands that persons with disabilities face barriers in the social environment. This is a different perspective from understanding disability from a medical model view. The medical model or traditional understandings of disability look at the person with the disability as having a problem or a deficit, right, that needs to be fixed or cured. The social model understanding of disability understands that persons with mental disabilities, physical disabilities, sensory disabilities experience many different types of barriers in the environment that make it difficult to participate on an equal basis of others. So that's really the starting point for thinking about disability from a human rights perspective, right? That people with disabilities are equal, have rights like all persons, and that we need to be orienting our perspective towards understanding the barriers that make it difficult for people with disabilities to participate, whether in the justice system or in education, employment, etc. Some of the other concepts are equality of access, that persons with disabilities should be able to enjoy equal access to justice systems like all other people. Legal capacity is assumed. Traditionally, persons with disabilities have very often been stripped of their capacity to take decisions. The disability treaty turns that around and says, no, persons with disabilities are equal and they have legal capacity just like everyone else. They may need support to take decisions, but we should not automatically be thinking about taking away their rights to make decisions. We should be thinking about support. A couple of other concepts that are really important. The idea that a person with a disability may need a reasonable accommodation. In other words, an adjustment to make a legal process or an educational process accessible to them. So those are individualized, reasonable accommodations, very important concept in the convention. The convention also talks about accessibility measures, and they are things to be provided in general to make the environment more accessible. And we'll look at different examples of those. And then finally, we need to understand that disability is diverse, right? And this needs to be taken into consideration when addressing the needs of clients with disabilities. So you may have two individuals, they are both blind, but they may have different types of access needs. We should not assume what their needs are. Rather, we should ask them what they may need to accommodate them. So turning now to one of the most important articles in the Convention on the Rights of Persons with Disabilities that relates specifically to access to justice. That's Article 13, and the slide that I'm showing now gives a summary of the different rights that are guaranteed under Article 13. So it guarantees the right to effective access to justice for clients with disabilities, for persons with disabilities. It guarantees the right to effective access to justice in all phases of the administration of justice, from the preliminary stage all the way through. It guarantees the right of persons with disabilities to be both direct and indirect participants in the justice process, and that includes serving as a witness in a case. It also guarantees the right to receive procedural and age-appropriate accommodations to facilitate their access to justice. And we'll give some examples of what that might look like. And then it also requires states to provide training to people working in the administration of justice, whether lawyers, judges, police, others, in order to help to ensure access to justice for persons with disabilities. So Article 13 also creates the right for procedural accommodations to allow for participation, right? So that means looking at accessibility related measures that might be needed, whether using assistive listening systems and devices, qualified sign language interpreters, or other tactile interpreters, for example, for someone who is deaf-blind. So we'll look in more detail at the different types of procedural accommodations that can help facilitate access to justice for persons with disabilities. The second really important document that has come out in recent years to help us think about access to justice for persons with disabilities are the international principles and guidelines on access to justice. These were adopted by the UN Special Rapporteur on the rights of persons with disabilities and developed in cooperation with organizations of people with disabilities, by other UN agencies, and with the input of governments as well. And there's about 10 principles, and they help us think in more detail about how persons with disabilities can be assisted in accessing justice. So principle 1 affirms that persons with disabilities have legal capacity and should not be denied access to justice. Principle 2 addresses the need to ensure that facilities and services are accessible to ensure equal access. Principle 3 talks about how all persons with disabilities, including children with disabilities, have the right to procedural accommodations in the justice sector. And principle 4 talks about how persons with disabilities have the right to access legal notices, information, and so on in a timely and accessible manner. So thinking about how to ensure that information that clients with disabilities need is accessible to them. Principle 5 of these international principles and guidelines talks about both substantive and procedural safeguards that are recognized in international law and that are important to guarantee to persons with disabilities. Principle 6 talks about having the right on the same basis as others to free or affordable legal assistance. Principle 7 talks about how persons with disabilities have the right to participate in the administration of justice. And then the final 3 principles, principle 8, persons with disabilities have the right to report complaints and initiate legal proceedings, whether they're a victim of a crime or they have other types of complaints. They have the right to have their complaint investigated, and they have the right to be provided with effective remedies. Principle 9 talks about the need to ensure that monitoring mechanisms support access to justice, so that we are making sure that we are actually monitoring the extent to which persons with disabilities are able to access the justice system. And then principle 10 emphasizes that all people working in the justice system must be provided with training and awareness raising, addressing the rights of persons with disabilities, which is what we are doing here today, talking about access to justice in the context of training. So that's a quick summary of the international principles and guidelines on access to justice for persons with disabilities. Now I'd like to turn to how we might identify the barriers that persons face in the criminal justice system or indeed in other legal sectors. We know from research that people with disabilities face many different types of barriers: physical barriers, communication barriers in the courts, in the justice system. We know that courts can be very intimidating environments for persons with disabilities, and without the appropriate adjustments, a person with a disability might have a real difficulty in participating. What are some of the general barriers that we see for accessing justice by persons with disabilities? These include things like attitudes and stereotypes about disabilities, assumptions that, for example, a person with a disability won't be a credible witness. That is a myth and a stereotype about disability. Persons may have a lack of understanding of the court system and its procedures. They need, in some cases, access to good information They may have an inability to communicate their requirements for communication assistance, which means that a lawyer representing a client with a disability may need to understand how to communicate effectively or provide information in an accessible format. Persons may have uncertainty about their rights to legal representation. There may be power imbalances, and this is, of course, is a problem if a person with a disability does not have access to accessible information. They may not have the time needed to consult a lawyer or other support people if they're not given that opportunity, and if they don't have the information they need. And often we face and see assumptions about the competency and reliability of persons with disabilities as witnesses in the criminal justice system. And in many countries, there have been barriers to persons with disabilities serving as a witness, which has been a big problem, and that's an area of reform, which is a huge issue. And the Convention on the Rights of Persons with Disabilities has helped to highlight those kinds of barriers and why they need to be removed. So I'd like to move into a little more detail now to have us thinking about the types of barriers that individuals with disabilities might experience. So physical barriers, that's an obvious problem that might be presented for a person with a physical disability, right? So where measures have not been taken to ensure the accessibility of physical environments, a person with a physical disability may have problem accessing a building, a courthouse building, a room, including counsel tables or jury and witness boxes. They may have difficulty accessing bathrooms, public service offices, including those used by victim support services. They may have difficulty if they're a criminal defendant in the space where criminal defendants are held. So there's a number of different types of physical barriers that persons might experience. And that's something we need to think about. And we are seeing in countries around the world much greater efforts to address the physical barriers that persons with disabilities face. In my country, in the United States, most of our courthouses were built over 100 years ago. And so it has been a very long and difficult process to ensure that we make the adjustments to these old courthouse buildings to ensure that persons with disabilities are able to access our courthouses, and it's an ongoing process. In my own city in Baltimore, our courthouse is over 100 years old, and it's not a very accessible building for any of us, although we've made some efforts to improve it. Communication barriers are another problem, and this is something that you may face as a lawyer who is trying to communicate with an individual with a disability who may be hard of hearing, who may be deaf, or who may have difficulties communicating. They may have a physical disability or an intellectual disability. So this is a very common issue that lawyers really need to think about so they can communicate effectively with their clients with disabilities. As I mentioned before, there may be a limited availability of information provided in accessible formats. So a deaf individual may need sign language interpretation. Person with an intellectual disability may need easy to read or plain language material. A person with low vision may need material in large print. In other instances, for example, someone who is blind, they may need material read out to them. They may need material in Braille if it's available, or assistive technology. Some of the other communication barriers may be, of course, lack of language assistance during a hearing, lack of communication equipment during hearings, difficulty communicating confidentially with lawyers in the court or the hearing room, and obviously where an individual with a disability speaks a different language, that will be an additional barrier. Another thing to think about in terms of the formalities of the criminal justice system and some of the terminology that we as lawyers can use, that can be an additional barrier for persons with disabilities who very often have been denied access to the educational system. So we know that persons with disabilities are disproportionately living in poverty. Around the world, persons with disabilities have less access to education and employment. And what this means is they may need additional assistance in understanding the terminology, the legal process, and so forth. And that's important for lawyers to think about when they are preparing a case and when they're communicating with a client with a disabilities, to understand the barriers that persons with disabilities tend to experience in general. What are some of the approaches that we've seen in different countries around the world? Many of these changes were brought on because of the adoption of the Convention on the Rights of Persons with Disabilities that's now been adopted by about 190 countries around the world. So in Jordan, where I had the opportunity to visit a few months ago, the largest court in the country is in Amman. And what they're doing there is trying to improve physical access to the court. And inside the building, they have a disability accommodation center at the courthouse where they can provide sign language interpretation, help people in navigating or getting around the courthouse. They provide plain language information. They have trained staff members who are working inside the courthouse, and they're hiring staff members with disabilities. There's an interesting study on access to criminal justice by the Disability Rights Unit at the University of Pretoria in South Africa. And what they did was look at some of the barriers that persons with disabilities face in the criminal justice system in 3 countries, in South Africa and in Botswana and in Zambia. And they had some interesting findings. They, of course, found that people report a number of different barriers, many of them communication barriers. They found that particularly persons who have been accused of crimes face significant barriers in accessing the justice system. And that it was particularly difficult for persons with hearing and speech impairments. And that in all of the countries, there really was not a coordinated response to those barriers. So they came out with a series of recommendations, including addressing procedural accommodations that are tailored to meet the needs of the diversity of persons with disabilities, training criminal justice personnel on disability rights and appropriate disability accommodations. Other things like revising the assessments of testimonial competence and the assessments of fitness to plead. So here then is the problems of barriers and denying persons with disabilities the right to be witnesses or the right to be a witness in their own case. They recommended requiring summons to be provided in different accessible formats, large print, for example, or other formats. They recommended including sign language and other non-spoken languages within the definition of the term language in court procedures, and providing an exception for persons with disabilities from the requirement to give oral evidence in person and in open court. So providing opportunities, for example, for an individual with a disability to give evidence in a separate room. This might be very helpful for a person with a mental disability, for example, who would find it very difficult potentially to give evidence in an open court. So those are some of the findings coming out of that study. Some other country practices to highlight: in Scotland, the Legal Services Agency has launched the Disability and Social Justice Project with the support of the Scottish government, again, to address some of the barriers that people with disabilities face in the justice system. They are providing specialist legal advice and assistance to persons with disabilities in Scotland, and they've hired persons who have disabilities, and that helps provide them with a very unique understanding of the different barriers that people with disabilities face. In Australia, we are seeing some jurisdictions, including New South Wales, provide very detailed information and training to lawyers and judges on how to accommodate persons with disabilities. And they've also published a disability access bench book for guiding judges on accessibility measures that can be taken to address the barriers that people with disabilities face. So now in the final part, I want to touch on some checklists of guidance on accommodating clients with disabilities. It's not an exhaustive list. There's, as I mentioned, disability is very, very diverse, but these hit just some of the different types of things to think about. So the first, what are some of the key accessibility factors we should ask ourselves before a hearing? Obviously, we want to know, do our clients have disabilities? Do they require any support or adjustments? How can we figure that out? Has someone disclosed their need for adjustments? Is there a way that that information can be disclosed? Physical access considerations. Have we thought about ensuring that a person is familiar with the courtroom and the facilities, how to access the courthouse or the court facilities or meeting rooms where lawyers meet with their clients with disabilities? Understanding if our client is a wheelchair user or do they use some other mobility aid? If so, are they going to be able to navigate in the spaces where we're meeting our client or in the courtroom? Are the court acoustics adequate for a person who is hard of hearing? Courtrooms can be very busy places and noisy places. Have we thought about that? We're asking an individual what will work for them. We may need to speak louder. We may need to speak more slowly. We as lawyers need to understand that so that we can best help to represent our client. And other communication assistance. Do we need a sign language interpreter? Do we know what the arrangements are for getting a sign language interpreter? And so on. Some of the other factors to think about, often persons with disabilities might need support people. We need to know if they have a personal assistance or needed a personal assistance. That's very important. Are there technology, equipment, or other access considerations that we need to think about? Have documents been provided before the hearings in a timely manner? Have we thought about, when we meet with a client, is there a particular time of day that's better for them? Is an individual going to have to wait for a long time? That might be challenging for some individuals with physical disabilities, for example. And is it going to be important to take breaks when we're meeting with a client? client who has a physical disability or perhaps a mental disability, will they need breaks? Will they need a break to use the restroom facility? Will they need a break because they tire easily? Will they need a break if they have an anxiety disorder and need to take a break? So those are some of the kinds of things that we need to think about. The most important thing, of course, is to know our client and to ask our client, are there any needs that you have, right? And to do that in a respectful and dignified manner, not to make assumptions about what a person needs, but to simply ask them what their needs might be. And then I have a few slides that are more specific. So looking at what we can think about for clients who are blind or who have low vision. And of course, people who are blind may have a complete or almost complete loss of vision. They may have low vision. They may be able to perceive light or shadow or shapes. So there's many different variations among persons who are blind or who have low vision. Some people have color blindness, so they cannot distinguish between colors, and some may have partial loss of vision only, right? So obviously, seeing or sensory impairments are varied, right? We shouldn't make assumptions about what a person can or cannot see. We should ask them what assistance they might need. So for persons who are blind or who have low vision, they may need different documents in accessible formats, if possible, like Braille or larger fonts. We may need to read the documents to them. They may have support people who help them read documentation. We may need to think about adjustments such as lighting or support and guidance from court staff. It will be important when serving a client with a disability to let them know before and during a hearing what the physical environment looks like. So describing the environment where they are, where court participants are positioned, and letting them know when people leave or arrive. So it's also a good practice for people to announce themselves each time as they start to speak for someone who's blind or has low vision. But again, people's needs vary, so it's best to ask people about their requirements when we're working with them. Checklist for persons with intellectual disabilities or cognitive disabilities. They may need more time to understand spoken and written information. They might have difficulty understanding abstract concepts or instructions. They may have difficulty with attention span and memory. They may become tired easily. So ensuring communication access is important, right? We may need to think about communication assistance or support persons who can work with a person with an intellectual disability. For lawyers and judicial officers, we need to think about speaking slowly and clearly, not treating a person with an intellectual disability as a child, but no, just speaking slowly, speaking clearly, using plain language, taking time to explain the proceedings, checking in with the person to see if they're understanding, and using breaks as needed. And then a caution is that persons with disabilities in the criminal justice system, a person with an intellectual disability often faces stereotypes about their disability. They're often maybe not believed. They might be seen as not being a credible witness. So we need to be very cautious about those stereotypes. Persons with mental disabilities or with mental health conditions. This is one of the most prevalent forms of disability globally. Certainly for lawyers working in the criminal justice system, we know that it is a highly stressful experience to be in the criminal justice system and that can make a mental health condition even worse, right? And there's many types of mental health conditions, mood disorders such as depression, anxiety disorders, and psychotic disorders, which would be very serious, more serious forms of mental illness. And this can affect people's health, including the way people think and feel and interact. And people with a mental health disability will have different types of requirements. So again, trying to understand what a client with a mental health condition might need without making assumptions is incredibly important. So some of the things we can think about for our serving clients with mental disabilities might be, thinking about, has a person disclosed to you that they have a mental disability? Often a person may not be comfortable doing that because they're fearful of being stigmatized. So lawyers should be mindful of the effect of an undisclosed mental health disability, and it may or may not be relevant for working with our clients. It's important to recognize that mental health disabilities can be episodic, right? So it might occur at different points in time, or they may be triggered by, by the stress caused by the situation. It may be important to take breaks. It may be important to ask the individual what would make them more comfortable if you're having difficulty communicating or getting through a meeting. And certainly people with mental health disabilities may be impacted by their in concentrating and remembering and processing information. So again, repeating, speaking slowly, checking in to see if someone has understood something, checking in to see if they need a break or if you need to repeat information. These are all some of the tips that we know can be useful. Checklist for persons who are deaf. So again, it's variation. People who are deaf have a complete or almost complete inability to hear. People who are hard of hearing are able to hear in some degree, and it's going to different people who are deaf communicate in different ways. Some use sign language, some read lips, some do both, right? So we need to understand that deaf people communicate in different ways, and we need to know what manner of communication they prefer. Interpreters should be provided for a person who does need a sign language interpreter. Persons who are deaf might need might have other requirements. They may be have low literacy. They may not know sign language. They may have a family member who is best able to communicate with them or help them communicate. It's important when we're working with sign language interpreters to ensure that the interpreters are positioned in a way that they can see very clearly the individual they are interpreting for. Interpreters really ideally need to be briefed before meetings, before hearings, so they can understand how they can best assist in sign language interpretation, whether in a meeting with a client or in the courtroom. It's important to explain what the process will be and check in to ensure that any adjustments and arrangements regarding interpreters are working effectively. It's important to speak slowly for sign language interpreters to fully understand and then interpret for the deaf person. And there will be a time lag, right? So a deaf person will need to receive the information from the sign language interpreter and then answer the question. So there'll clearly be a need to give an individual who's deaf time to answer a question. And if you're not understanding either what the person is saying or the information being conveyed from a sign language interpreter, don't make assumptions or pretend to understand. Ask for clarification. And I've put up on this slide some additional resources, including the international principles and guidelines that we went through, as well as some other reports that are helpful when thinking about access to justice for persons with disabilities. And I'm going to leave it there. I've given you just an overview and a snapshot that I hope is useful, and I hope it gets you thinking about how you might best serve persons with disabilities in your work with clients. So I'm going to stop sharing my screen and open it up for any questions or comments that you may have.